McKinney versus McKinney. I have a corrected motion to require the defendant to remove his dogs from the marital residence, and then a motion to set the trial, remove objections, and revisit temporary support.
Yes, Your Honor.
All right.
Your Honor, the issue, mine being the most simple, is Mr. McKinney. There's animals that have been left at the house that are unattended. He keeps them locked up in a garage, does not come attend to them, and when he does, he doesn't give notice to the mother. She has exclusive possession. He oftentimes doesn't feed the dogs or provide funds in order to feed the dogs. And we're just asking that she be allowed to either have the dogs returned to the Humane Society, or he can come and pick them up and keep them.
The position is that he does not have the ability to keep the dogs, and the court gave the mother possession of the.
Well, if he doesn't have the ability to keep the dogs and she doesn't want them, what do we do with them?
Well, the statutory injunction mandates the parties maintain the status quo regarding marital property, and this was an obligation she understood when she came before the court and said, "I'd like to have the marital residence."
But that's the whole purpose of temporary hearing, Mr. Bates, is if we're going to eventually get to a position where these dogs are going to have to be dealt with as property, and if they're going to be dealt with as property, he's either going to want them or he's not going to want them. If he wants them, he's going to have to try to make arrangements for them at some point. I don't know what we're doing about the house, but obviously if we do something with the real property in the interim where it's sold or something like that, it's coming, I suppose you could say.
That's correct. My client cannot have the dogs where he lives. He's living with his parents, and there's not a place for them.
How many dogs are there?
3.
And what type?
Mine's 57. A little bit of everything.
Okay. Well, I'm a dog owner, a dog lover, and I don't, I don't have any desire to see dogs having to be put down, but we need to have some sort of resolution of this issue, because if they're his dogs, he's going to have to find a way to take care of them. If they're not his dogs, or if he doesn't want them, then they'll be either her responsibility or that she'll have to do what she wants to with them. So, all right. Anything else?
Well, that's not, we just, again, Your Honor, as somebody who has a babysitter for her, I carry my dog to daycare or comes to work with me. So again, we understand, but the fact is it's a financial issue and it's a caring issue, and these dogs being locked up are not appropriate, but they are under the law, they're deemed property issues. So we wanted to have permission to turn them over to the Humane Society. Again, if he wants them, we just wanted him to have the opportunity to keep the animals if he wanted them. My client's financially not able to do it. It's causing an issue because she does have exclusive possession, and he just shows up. He'll show up and again, go in the backyard and play with the dogs, which is not objectionable if you scheduled thing. If it was like, is it convenient? Can we come over? It's her time with the kids. He's like, kids, you need to go and care for the dogs. It's just an overall untenable situation, Your Honor, with the animals. So we just want permission to turn them over to the Humane Society.
Would you want to put on any proof about it?
Yes, Your Honor.
Come up, please, Ms. McKinney.
I'll share something about the truth, so help you God.
Let me see.
State your name for me, please, ma'am.
McKinney.
And Ms. McKinney, let's refresh the judge's memory about your case. You and your husband have 3 children. Is that correct? What are their names and ages?
Brayden McKinney is 16, Radley McKinney is 15, and Finn McKinney is
Scoot up a little bit towards that microphone if you will.
You speak up. Okay. And Finn is how old?
8 years old.
And Finn is on the spectrum. Is that correct? Does he have counseling regularly?
He has therapy through the school system, and then once a week at in hearing.
Now, you and your husband have separated for how long now?
April.
Okay. And again, we're not there yet, but it's going to be your desire to retain the marital residence. Is that correct?
Yes.
And as a result, during the course of y'all's marriage, did y'all acquire certain animals? And what type of animal?
He needs to be able to hear everything you're saying, so your voice is pretty soft.
Okay.
You just need to speak up loudly. Project your voice if you will.
Okay. If you could, just speak out so I can hear you, okay? What type of animals did y'all acquire during your marriage?
We have cats and then the 3 dogs.
Okay. Are the cats inside cats?
We have 3 inside cats.
Okay. And do you take care of those?
I do.
Okay, and are there dogs?
There's 3 outside dogs.
Okay, and when you say outside dogs, you live where?
I live in
What town do you live
New
in?
Johnsonville.
Do they have a leash law?
Yes.
Okay, so are your dogs trained to the point of where they stay in your yard?
No.
Do they have to be, when you go outside, do they have to be watched and managed?
Yes.
Are you able, what do you do for a living, ma'am?
I'm a registered behavior technician.
Okay, you just recently gotten that job, is that right?
Yes, ma'am.
Before, were you just an aide with the school system?
I was, and then I went to the daycare as an assistant director.
Okay. Do you, and you and the boys live at the house, and he has residential time with the children, is that correct? How are the dogs tended to and where do they stay? Just kind of give the judge an explanation of what goes on with these animals.
So we have a detached garage, and the boys will take them from the detached garage inside there to the pen that he just recently had built before before he moved out. And so they go from the big pen to the garage, the pen, just back and forth. And sometimes if I don't remind the boys to take them from the garage to the pen, they get left in the garage.
For how many days have they been left in the garage?
I counted 2, and then finally I was like, boys, they have to be outside.
Okay, are they crate trained dogs?
No,
Do they just use the bathroom all over the garage?
my boys clean it up. Yeah.
Okay. And have you asked Mr. McKinney to come in to get the dogs?
I have several times.
And what's his response been?
They're everybody's dogs. I don't have a place for them. They're staying here. I built this $7,000 pen, and that's where they're staying.
When did he build a $7,000 pen?
I guess right before we split, right before our hearing.
It was after we had filed for divorce, correct? Was it right at the time we were filing
It's
for
about
divorce?
that time, yeah.
Okay. Did you know he was spending that type of money?
No, ma'am.
You happy for him to remove the fence and take it with him?
Absolutely.
Is it a pen?
So the front side of the front of the house is wood, and then it's chain link fence. But it's not big enough for these 3 big dogs to just run.
What size dogs are they?
They're about this big, 3 of them.
Okay.
And they bark all night if they stay out overnight. Keep everybody up if they're not put back in the garage.
And are you able to tend to them?
I mean, yes, I can, but I don't want them.
Okay. But again, you're working Monday through Friday.
Yes, ma'am.
Okay. Do they behave? I mean, are the dogs, if you let them out, do they?
They're gonna run off, and they've
Okay.
run off before.
They don't just they're not obedient enough to go from the garage to the pen by themselves.
Maybe a few of them, but there's one that will just take off and be gone for days. And I've had police call me, say, hey, your dogs are out. I'm like, call him, because they don't listen to me anyway.
When was the last time that happened?
Last week,
Last week.
my boys went to take the dogs from the garage to the pen before school. And I guess they didn't tell me, but one of them had ran off. They didn't let me know that, but the cops had called me. I said, well, I'm at work.
Now, your children have extracurricular activities. Your oldest is in the band?
Yes.
Also in Beta Club?
Yes.
And does he have other activities?
No, just band, jazz band, and
Okay.
Yeah.
And your middle son, Braden, plays basketball.
Bradley plays basketball.
And then Finn,
He's autistic, and he's got his therapies in the afternoon.
and again, is Finn able to deal with the dogs?
No, actually, we were outside yesterday in the backyard, and they barked so much and so loud that it scared him that we couldn't even play in the backyard. We had to move up to the front yard.
Okay. And are you financially able to care for these dogs?
No,
Have there been issues about keeping them fed?
yes, we had to remind him, the boys would remind their father to buy dog food, and I would too.
Are there occasions that he just comes over and hangs out?
Yes, he'll just come up in the middle, like at nighttime, to make sure that they're put up in the garage at the end when he has the boys, when it's his time.
Does he call and tell you he's coming?
No.
And is that an issue?
Yes,
Now, to your knowledge, he's had people, do you believe that there are people watching you?
yes, ma'am.
Neighbors specifically?
Your Honor, I'm arguing relevance as to the dog issue.
What is the
Yeah,
relevance?
it just goes from him, it's a stalking issue, Your Honor, with him coming up when she has exclusive possession. And then him coming, and again, I'll move on. from that
I
standpoint.
sustain the objection. There's nothing pending before me today that deals with that issue, so sustain the objection.
You want the dogs gone? That's all. Thank you.
Mr. Bates, you may cross-examine.
The dogs were there when you were granted exclusive possession of the residence.
Yes, sir.
And do the three boys love the dogs?
I think if they love them, that they would pay more attention to them.
So you don't think they love them?
No.
And you just don't want to deal with them. You can deal with them, you just don't want to.
I'm not in a place financially to deal with them now.
Since April 1st, you've received a $4,000 work bonus, correct?
Since April 1st, no.
When did you get your work bonus?
At my old job, it was like sporadic. We never knew that was coming.
At your current job?
In my current job, I haven't gotten a bonus.
This year, you've received $4,000.
Not that I recall, no. I had gotten a bonus from my last job.
When did you receive that?
Those pay stubs that I had given, I don't recall the date.
You had a pay increase, correct?
From my old job to my new job, yes.
And what was that increase?
I get paid now $20 an hour, so roughly $6 raise.
Per hour. So yes,
Yes, sir.
you didn't want to cohabitate while this case was pending.
With my husband in the same house, that's no.
But your position is you don't want to take care of some of the responsibilities of the home that were present.
I take care of the cats and I take care of our kids. The only thing I don't take care of is the dogs that he wanted.
Are you just, there's nothing physically preventing you from doing this. You just don't want to.
Okay, so I don't want that.
Very well. Thank you.
Nothing further, Your Honor.
Thank you, ma'am. You may step down. Do you have any other proof on that issue?
No, Your Honor, that's not correct.
Mr. Bates, you have proof you wish to offer?
My client can't have them at the current home. I don't think that's in dispute.
I'm sorry.
He can't have them at his current home. I don't think that's in dispute.
Okay.
So
All right.
I don't see anything.
Well, I'm going to, the last thing I want to do is to have dogs, put in a humane society, but by the same token, the mere fact that the dogs were there when she was granted exclusive possession of the home does not obligate her to tend to animals that she doesn't want. So this court's order is that the dogs will be sold, or they can be awarded to Mr. I'll tell you what I'll do. I'll award them to Mr. McKinney, and he can do with them as he please, but he must do something with them within the next 30 days. I'll get him through the holidays, and then he's got 30 days to try to do something with them. He can either keep them, he can dispose of them, but he has to remove them from the home within 30 days. All right, next issue.
Yes, Your Honor. This is to revisit support. The mother just testified that she now makes $6 an hour more. I'm really not sure what her gross income is, because she continues to say in discovery, she said at the April 1st hearing, what her net income is. Child support's based on gross, not net. But if we just take her word for it, $6 an hour times 40 hours a week, that's $240 a week, which is 52 weeks divided by 12. That's approximately $1,000 more than at the April 1st hearing. The court ordered the current child support $1,282. The first request is for us to recalculate based on the current gross income of the mother. The second request would be for the court to reconsider some form of support. The court is obligating the father to pay exclusively the mortgage and the other expenses related to that home. Child support is $1,282 as it currently is. So, Your Honor, we just ask you to run a new child support order and then obligate the mother to pay some portion towards her living expenses based on her increased income. And we've attached her discovery responses to our motion on this issue.
Well, Your Honor, I take significant issue with what Mr. Bates stated in stating that her income at the previous hearing was not appropriate and somehow not her gross income. Mr. Bates was not the attorney of record at the time and was not present during that hearing. Ms. Haley Parameter with the Cordell and Cordell Law Firm was the attorney of record at the time. Specifically, Your Honor, I have the transcript of the ruling. Right now, what has been established is that Mrs. McKinney makes $1,800 per month at her present employment. She may make additional monies off of her cake business on the side, but it sounds like, to me, it's just nominal, $30 to $50, I think is what she testified to. Mrs. McKinney has produced somewhat varying evidence regarding, Mr. McKinney has produced somewhat varying evidence regarding his income. We don't have a paycheck stub from either one of them, and as a result of that, I can't go on the evidence before me. The evidence before me is that he made $118,000 according to his testimony in 2023. That equates to a gross monthly income of $9,833.33. His testimony today is he is making $40.94 an hour, and that would be $1,637.60 weekly. Multiplying that times 52, his gross income is $85,155, which is clearly less than what he made last year. So we expect the difference to be made by overtime or extra hours. And Your Honor calculated the income and expense statement that she produced showed that she had a shortfall of $2,690.51. So I've been asked to order that she be allowed to live in the home and that he be required to pay the mortgage and utilities. The mortgage is $1,200. Mr. McKinney then tried to, and it was $1,401. So Your Honor, again, Your Honor already made an affirmative finding that he did not produce any income at the last hearing. The only thing that was produced is we showed a tax return. He didn't bring in a paycheck stub. And to come in and say that she somehow misled the court is very disingenuous. And additionally, she had a shortfall of over $2,000 a month on just her income and expense. And as a result, Your Honor, had him pay the utilities and the taxes. So we're just, in order to modify it, again, I assume we've got an income and expense statement and a new paycheck stub. The evidence will also show that Mr. McKinney is taking off significant amounts of time. Your Honor may recall this hearing is that he has an affinity to just one of his children. He does nothing with the oldest, very limited time with the youngest, but he thinks that his son Braden, and I hope he is, but is a basketball phenom. He takes him to Memphis. He carries him different places. He continually calls him without consulting with the mother about let's go to Jarrah and play basketball, take some lessons and do this and do that. And he takes off work. This past week, I think he took off 3 days of his schedule, and then criticized my client because she stayed home with the autistic child and didn't go to Braden's basketball game. So because he took off. So again, Your Honor, the order is the order. We're ready to set this hearing. I do have written discovery that's going out this week to Mr. McKinney after we were not successful in mediation, and then we'll be ready to set this for a hearing.
Well, let me ask this question. Looking at the order that was entered from back in the April hearing, it shows the father's income at $7,096 per month, and the mother's income at $1,800 per month. So that's less income shown for him on the calculation of child support than what I made as a finding. Do we know why that figure was used?
At the transcript, it shows that there was, the argument is that the father had overtime, which he admits he did, which in prior years. He's not electing to do this overtime while, now, which is subject, but the court also reserved the retroactive application. If the court found that to be incorrect, the court reserved that issue because that's just his income is presented as just his standard income without overtime.
And
Go ahead.
I'm just saying, it's on page 31, Your Honor. I didn't go on and read that. Your Honor, which income did you calculate child support, the $7,096 or the $9,833? And Your Honor said, well, the only evidence I have for his current income is $7,096. And so far, the purpose of temporary hearing, we're going to use that at the final hearing. Obviously, we will have more at that point in time.
All right.
So he didn't produce any income information. He just testified what his hourly rate was.
Mr. Bass, it's your motion
Yes, Your Honor.
to reconsider the child support and contributions so you can put on your proof.
All right, I call Ms. McKinney then.
Ms. McKinney, if you'll come back around, I will remind you remain under oath.
McKinney, at the April 1st hearing, what was your hourly rate?
I was still at Giant Leap April 1st, $14.50, I believe.
Okay. You stated in your transcript that it works out to approximately $1,800 a month. Was
Okay.
that your net take home or was it your gross?
I believe it was my net. It's what I brought home.
Okay, so that's what you brought home.
Yes.
Do you know what your gross was?
No, I can look back and see if I can have my stubs.
All right. On your statement of income and expenses and discovery, you provided your net
Okay.
of, I'm asking you, of $2,100, a little under $2,100. Is that correct?
That's what you had. That's what I said then yes.
All right. What is your gross rate of pay?
I'm not sure.
What are you paid by the hour now?
Now 20, but it's based on if I see the client that day that I'm working with at my job now. If I don't see the client for the one-on-one session, I get paid half of that, which is $10 an hour.
And in discovery, which was attached as Exhibit B to this motion, I asked for all documents showing your gross income and other earnings for the current year. You remember seeing that?
Yes.
And your response was, Mr. McKinney removed all the files with this information when he left the marital residence.
Right.
When did he leave the marital residence?
I believe it was around April 15th.
When did you take your new job?
My new job recently?
Yes, ma'am.
End of September.
So you have pay stubs of your current job, correct?
Yes.
That Mr. McKinney could not have taken.
Right.
All right. And you have not provided those in discovery, correct?
I just emailed them to Jennifer.
Okay. And fair to say you're making more.
A little bit more. It depends, like I said, it depends if I have one-on-one session with my client that day. If they're absent, then I don't get paid $20 an hour.
And your child support was based on your net income, not your gross.
Right.
And you're still insured by the father, correct? That's it.
Ms. McKinney, describe to the court what job you do.
I work with special needs kids at the Brooks Center. I do one-on-one sessions.
What is the Brooks Center?
It's a therapy place here in Waverly for ABA.
And do you have any individual schooling or?
I do. I took the training and then I get supervised. while working.
Did your company give you that training? Did your employer send you to that training?
No, I took it upon myself and then I applied when I needed the position.
And what type of training is it?
It's a 40-hour training online and then you study and take the exam in Nashville.
And so what do you hold a certificate in?
Registered behavior technician. It's ABA therapy, which is applied behavior analysis.
And that assists you with dealing with your son, Finn, is that right? And prior to September of 2024, were you employed by who?
Before this job, I was Giant Leaps.
Giant Leaps. And how much was your rate of pay?
$14.50.
$14.50 an hour. And did you work 40 hours?
Yes, it depends if I got off early to pick up the boys from school, or if I got off early to take them to therapy.
But you were employed as a 40-hour employee.
Yes. Yes, ma'am.
At $14.50 an hour. And then now you are making what?
$20 an hour if I'm one-on-one with my client.
Well, but how much is that? How many hours a week do you do one-on-one with your client?
I mean, it depends if she has a doctor's appointment. I can't tell you.
What's the average?
A week, about 30.
And then, but you work 40 hours, correct?
Between 30 and 40 hours.
Okay. If the child is you have an individual child assigned to you or multiple children?
Individual.
Okay. And if that child is sick, has to leave early, has a doctor's appointment, do you go home?
No, I stay there and I make the $10 an hour.
Okay. So your company allows you to do clerical work. So again, on an average, are you making $30 an hour? I mean, excuse me, for 30 hours, you're approximately making $20 an hour. Is that correct?
Yes, ma'am.
Which would be $600 a week for average for your income, and $10 an hour for the remaining 10 hours.
Yes, ma'am.
Is that correct? So you're averaging $700 gross a month. Is that right? Okay. So when we produce this income and expense statement, that's this to her. And if I could have one for the court too, if you'll pass one for the court. This one, this is stuff, right. When we had you fill out your income, are you testifying that when we gave you the form that said gross income, that you put net income on that? Or do you recall, did you fill out the discovery request before you took your new job or after?
I'm not sure.
Because you would be making about $3,000 a month if you're averaging $700 a week.
Yeah, and still that depends if I'm getting that many hours.
Okay. Have you gotten that many hours?
Not a total, I have not gotten. My hours are not set.
What time do you work from and to?
I work 9 to 3 with my client.
9 to 3, if she's there every day. Okay. But what time do you work at your job?
I can go in at 8, which is all, like if I want to or not, but I usually go in at 8 after I take the boys to school, and I work admin hours, which is $10 an hour.
Mm-hmm. So for an hour a day, you're working administrative duties.
Yeah.
And then from 9 to 3. Okay. And have you done that every week?
Yeah.
How many occasions do you think that you have not had your child, your ward there, the person that you're working for?
At least 3.
At least 3 days
Yes, 3 days.
since September?
Yeah.
And here we are in November?
Yeah.
All right. That's all. Thank you, ma'am.
Bates, you have any follow-up?
No, Your Honor.
Thank you, ma'am. You may step down. Bates, you may call your next witness.
That's our proof, Your Honor.
Ms. Roberts, you have any proof you wish to offer?
Well, first I would ask that it be dismissed as there's no proof of the husband's income in the record. And in order to make any modification, the court would have to have both parties' income. Statute on anything talks about need and ability to pay. On the spousal support that Your Honor modified, as well as the child support, it takes the mother's income, the father's income, the number of days that the parties have each child, cost of health insurance, the cost of daycare. So there's insufficient evidence been put in the record to make any modification at this point in time, and we respectfully request that the motion be dismissed.
But the first is, the mother's income was wrong when the court entered it from the April 1st hearing. It was based on the mother's net income. That's the low-hanging fruit of this case, just to revisit the April 1st hearing. Under Rule 54.02, it's a non-dispositive order, so you don't have to prove either a Rule 60 application. It's just, it was wrong. And then if the court wants to reserve, the mother's income's changed, the court contemplated that possibly the father's income was his stated income and what he's made historically. There's if he does get overtime, the court can recalculate that, so the court can reserve that. But the mother, since then, she's made a significant raise, and so the issue is just squarely on what the mother's income was wrong at the April 1st hearing, and also substantially increased. But I'm happy if the court wants to hear from my client. It's not
Not a question of whether I want to hear from her or not. The obligation under the law is on both of these parties to establish their income for purposes of child support. At the first hearing, Ms. Roberts is correct that Mr. McKinney did not produce actual proof of his income other than his testimony, my recollection is. And she did testify about what her income was, but I think it was incorrect in that it was calculated based on her net income. But that is a temporary order. And the fact that he did not supply copies of or proof of his income makes suspect what it was. I think in any temporary order, the court reserves the right to adjust the child support accordingly. And at the final hearing, certainly I expect both of these parties, having completed discovery, to have actual proof of the income rather than just their testimony, pay stubs and so forth, to establish that what their income is actually presently at. So for the purposes of your motion, I'm going to deny the motion, but reserve it for hearing at the final hearing to make any adjustments on the child support calculation and any retroactive calculation adjustment. Of the opinion that until we can, I mean, the wife has the opportunity to try to do discovery on Mr. McKinney's income during the time period prior to the temporary order to establish whether or not that income was actually accurate for him. So in both of them, in my opinion, have failed in their obligation to actually prove what their income is for purposes of child support. So the temporary order shall remain pending the final hearing, but we can give you a final hearing in February if you'd like to have one. So that's in front of me since I've heard temporary matter.
That's fine, Your Honor.
We could do February 5th, 6th, or the 24th.
February 5th, 6th, or 24th.
February 5th. 6th, which 24th?
Yes.
For the 24th.
Mr. Bates?
Not a problem. Your Honor.
What?
Nobody else have changed their days that day in any other counties.
What, February 24th.
I'll prepare orders that'll,
All right.
discovery will be subject to an agreed protective order. We can work out the language, no dissemination or duplication. The motion for temporary revisit of support is denied. The father will have 30 days to remove the dogs, either sell them or dispose of them otherwise.
All right.
Except for final hearing.
Except for 24th here with the court.
Thank you, Your Honor.
And you did say the issue of retroactive modification of child support will be reserved.
Both parties have the right to modify finances retroactive.